He wanted to see the park rule. I showed him about ascent or descent, airplane or whatever. It's the same thing. He wanted to sit here and argue it wasn't an airplane, so.
Well, you know what I'd do with him?
Jail.
I'd write him a ticket, take his ass to jail, and release him down there. Yep. That's what I'd do.
Yep. Okay.
Because there's rules to follow.
Yep.
Hello, thanks for joining me today. Michigan is a very drone-friendly state. There is one uniform set of laws that govern ownership and operation of unmanned aircraft. MCL 259.305 reads in pertinent part, except as expressly authorized by statute, a political subdivision shall not enact or enforce an ordinance or resolution that regulates the ownership or operation of unmanned aircraft, or otherwise engage in the regulation of the ownership or operation of unmanned aircraft. This law does not regulate citizens like you or me. Rather, this law regulates the authority of local government by removing their ability to constrain the ownership or operation of drones in any manner that is more strict than state law. Most local politicians are part of the community, they are good people, and they want to follow the law. But every now and again, a municipality comes along with the attitude that state laws don't apply to them, especially if these politicians feel passionate about an issue. Genesee County attempted to prohibit drones in county parks a few years ago by enacting an ordinance that would make drone possession punishable by up to 90 days in jail. It's difficult for me to understand the psychology, and I just assume that it's some kind of authority complex that allows an entire county commission to pass a regulation even though each and every one of them knows it is contrary to state law. It's as if they don't care what the law says. They don't want drones in their parks. Except words mean things, especially in the courtroom. Michigan Coalition of Drone Operators is an organization that was formed in part to protect pilots from these types of overreaching government regulations. MCDO named the chief of park police and director of the park in a lawsuit and was successful in getting the 7th Circuit Court to issue a ruling prohibiting Genesee County park employees or park rangers from molesting lawful drone operators. Since that time, MCDO Legal Counsel has reached out to other municipalities with unlawful ordinances on the books, and all have taken appropriate steps to remedy the problem, except one. Ottawa County has the following ordinance. No person, while on commission park property, shall use or operate any remote-controlled airplane, helicopter, drone, car, boat, or similar device unless prior written permission is obtained from the commission or its agent. For the record, according to a FOIA request, the commission has approved exactly 0 drone permits. So when Ottawa County, located on the west side of the state, was contacted about their unlawful drone ordinance, MCDO Legal Counsel received this reply. While we never want to encourage litigation, if you or your organization chooses to sue Ottawa County for its limited restrictions over its properties only, we look forward to setting the record straight and obtaining the appropriate Circuit Court and Court of Appeals decision, or using Ottawa County and its allies' clout in the legislature after getting the impetus to make legislative changes in the unlikely event a court decision on the legislation did not run in our favor. I think that's a long run-on sentence. We will not rest if drones in our parks are allowed to harass or endanger our peaceful visitors. Very truly yours, Ottawa County's Corporation Counsel. I am not an attorney, but I think this is lawyer speak for, come at me, bro. It is always amusing when a municipality who knows they are clearly in the wrong chooses to fight tooth and nail, spending countless hours and piles of money on a legal battle they know from the start they cannot win. In the attachment that goes along with Mr. Van Essen's email, it basically indicates that since Ottawa County has general authority to make rules regarding county parks, they can therefore regulate drones. This argument is laughable at best. This is the argument that most municipalities use when faced with a preemption law that prohibits certain conduct, and it loses in court every single time, because when 2 or more statutes relate to the same issue, the more specific one controls. What Ottawa County likely does not realize is that MCDO has a secret weapon. We have, in my opinion, the preeminent aviation attorney in the entire state, Dean Greenblatt. When it comes to attorneys who specialize in this area, we have the best of the best. Whether you operate a drone or fly manned aircraft, if you are hassled by local government or you get a letter from the FAA, Dean Greenblatt is the first person you should call. This lawsuit, MCDO versus Ottawa County, has just been filed in the 20th Circuit Court, and we are currently awaiting a response to the complaint and our first court date. It is unclear at this time if the hearings will be in person or virtual. I will be sure to keep everyone updated, and if you want to send donations, the info is in the description. Questions? Comments? Leave them below. Thanks for watching. Bye-bye.